How late can the truth arrive before it starts deciding things for everyone in the room? I do not know the answer to that. I have thought about it for 19 months, and I still do not know. What I do know is that the silence after I finished speaking from the bench felt like a room holding its breath around a wound it could finally see. This case is why I keep asking that question. Let me tell you the case. Before I tell you about the charges, I need to tell you about the girl at the center of them. By the time most people hear about a case like this, the person it happened to has already been turned into a count number in a file tab. She was not that to me. She was Naomi Brooks, and from the first morning I saw her, I understood that most of what mattered here would never fit cleanly into the language the law gives me. Subscribe. Not for me, for the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. Naomi was 17 when she first came into my courtroom. She did not move like a girl waiting to be rescued. She moved like someone who had learned that if she wanted steadiness, she might have to supply it herself. She kept her shoulders level, but her hands stayed folded one inside the other so tightly that the skin across her knuckles turned pale. When a paper slid crooked in front of her, she straightened it before she read it. I have not forgotten that. There was tenderness in her that was easy to miss if you only looked for tears. During a recess, the victim advocate dropped a pen. Naomi bent first to pick it up, even though everyone in that room was there because she had been the one made to live without care. Small things tell the truth when people are tired. That one did. The defendant was Calvin Mercer, 46 years old, licensed foster parent, clean shirt, pressed slacks, a gray tie tied too short. He watched reactions more than he watched testimony. His eyes kept moving to the gallery, then to counsel, then to the clerk, then back again. Men who have spent a long time shaping what other people can know often do that. They scan for the place where a story might get away from them. There was one thing about him that was plainly human. Naomi coughed once, a dry little cough she tried to hide in her sleeve, and Calvin half stood from his chair before he caught himself and sat back down. That made the whole case worse for me, not better. It meant he knew what concern looked like. He had not failed because he could not recognize a child's need. He had failed after recognizing it. The incident happened on February 14, 2024, at 6:42 p.m. at 601 West Harlan Street, apartment 2B, in Franklin. Naomi had come home with papers for a summer law program at Central State. The packet needed a birth certificate, a social security card, and proof of guardianship. She said she asked Calvin for those documents. He opened a metal lockbox, looked inside it, closed it, and said, "That file is mine until I say it isn't." She said the packet had her name on it. He said, "I pay the bills, so I make the rules." Then, according to Naomi, according to the neighbor in 2A, and according to the first officer through the door, he bent the packet once across the middle and tossed it onto the kitchen counter. When she reached for it, he caught her wrist and said, "You are a child living in my house. That is all the identity you need." Naomi pulled free and ran into the hall. Elaine Porter from apartment 2A opened her door before Naomi even finished knocking. Mrs. Porter called 911 at 6:49 p.m. Officers arrived at 7:03. When they searched the apartment later that night, they found the lockbox under Calvin Mercer's bed. Inside it were Naomi's birth certificate, her social security card, 2 sealed letters in her mother's handwriting, 3 school awards, a debit card tied to survivor benefits, and county placement papers. The first filings I read were bank records, placement reports, seized property logs, and a county review form that listed Naomi's father as unknown. It was a neat little word in a neat little box, unknown. I looked at it longer than I needed to. There is grief in paperwork. It sits there quietly, waiting for somebody to notice what got flattened in order for the page to stay orderly. One thing most people do not know is that the court can treat a sealed letter as evidence of wrongful withholding without opening it in public. If the issue is who had a right to possess it, the contents are not always necessary. So I ordered Naomi's mother's letters preserved and protected. Privacy matters, even when almost everything else has already been taken. I could decide what the record proved and nothing outside it. The legal charges were financial exploitation of a minor, unlawful withholding of vital records, tampering with mail not addressed to him, misdemeanor assault, and one identity-related count tied to Naomi's benefit card. The money stretched over 19 months. The records count stretched over 3 years. What a child feels as endless often reaches my desk as dates lined up in columns. From the bench, I watched the entrances closely. Naomi came in first on the first day of trial with the victim advocate beside her, but she walked half a step ahead. That told me she was not leaning on the advocate so much as allowing the advocate to be there. Her eyes did not go to Calvin. They went to the evidence cart by the clerk's desk. No one else in that room had my angle. I could see she was looking for proof before anything else. Calvin entered through the side door with his lawyer and stopped for less than a second when he saw more people in the gallery than he expected. Mrs. Porter was there. Naomi's school counselor was there. A county worker was there. Calvin did not look at Naomi. He looked at the back exit. From the floor, people see faces. From the bench, I see where people imagine leaving. There were 3 silences in that courtroom that day and in the days that followed. Not the small quiet between one question and the next. I mean the kind that arrives when something true enters the room and no one knows yet what shape to make around it. I'm going to tell you about all 3 because I understood the case differently after each one. Silence 1 came when Naomi took the stand. By then, the jury had already heard the basic facts. They had seen photos of the lockbox. They had seen the bent summer program packet and the card statements. The prosecutor asked Naomi what it felt like to see the contents of the lockbox laid out on the evidence table after the police opened it. Naomi looked at the worn corner of the witness stand and said, "My name was in there. That was all." 4 words. The room stopped. It lasted maybe 6 seconds, long enough for the court reporter to lift her eyes, long enough for a juror to stop writing in the middle of a line, long enough for me to hear the vent above the jury box click and keep humming. The prosecutor broke it by saying very softly, "What do you mean by that?" Naomi said, "Everything that proved I belonged to myself was in that box." After silence 1, I understood something the charges alone had not told me. This was not mainly a money case, it was a selfhood case. Calvin Mercer had hidden the small official things a young person needs to move through the world without stopping at every door to prove she exists. A birth certificate, a social security card, mail in her own name, papers for her future. You can take years from a child that way without ever leaving a bruise big enough for a photograph. The first evidence wave was steady. Bank withdrawals, app logins, missed deadlines. Naomi's school counselor said Naomi lost her place in the Central State Summer Program because she could not produce required documents by the deadline. Mrs. Porter said she heard Calvin say, "She asked too many questions for a girl who has nowhere else to go." I wrote that down. Naomi said one more thing before the verdict that has stayed with me. When defense counsel suggested Calvin had only kept important papers safe, Naomi said, "Safe for who?" She did not say it with anger. She said it like someone laying a simple truth on the table and stepping back so everyone else could see whether they were willing to look at it. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe, stay with it. The defense was careful, and I want to be fair about that. They did not insult Naomi. They did not treat her as foolish. They argued that foster parents often hold documents so they do not get lost. They argued that state payments cover household costs. They argued that a strict house is not the same as a criminal house. Some of that came close because some of it was true in the abstract. The law asks me to separate what is lawful from what only looks lawful at first glance. That pause ended when the state showed what Calvin Mercer had done with Naomi's benefit card and how often he had lied to the county about her records. A forensics analyst traced 7 transactions from Naomi's card to a sports betting app on Calvin's phone. A county caseworker testified that Calvin had reported Naomi's documents as not yet located in 3 separate review meetings while keeping them in a lockbox under his bed. Then Calvin took the stand. He said, "I run a tight house." He said, "Kids need structure, not choices." He said very quietly, "I only kept things back because she was not ready for the truth." That was the first time Naomi closed her eyes. I had a yellow legal pad in front of me. When he said, "I thought it was better for her not to know," I wrote it down. I looked at it for a long time before I moved on to the next page. He believed that sentence helped him. What it told me was that he had renamed control as protection so completely that he could say it under oath and hear nothing wrong in it. There was another sentence from him that mattered to me. He said, "I never laid a hand on her except to keep her from hurting herself." It sounded quiet. It was still wrong. Force had already been turned into concern inside his own telling. Once a person does that, they can live inside that lie for years and call it duty. In the middle of his testimony, while counsel argued over an exhibit number, a memory from my own life came back without warning. I was 10 years old, standing in my mother's kitchen in socks because the floor was cold. She had a metal drawer beside the refrigerator. In that drawer, she kept our birth certificates, insurance cards, and school photos under a folded dish towel. Before church, she used to tap the drawer once and say, "If anything ever happens, this is where your name lives." Then the lawyers finished arguing, and I was back in the courtroom. The defense made one last effort that gave me real pause. They showed photos of the apartment kitchen. The counters were clean. There was food in the refrigerator. Naomi's school photos were on the fridge with magnets. Neglect is sometimes easier to identify when the room itself looks neglected. This room did not. Then the prosecutor enlarged the inside of the lockbox. Naomi's sealed mail was rubber-banded beneath Calvin's betting slips. My pause ended there. Silence. Two came after the last question of Calvin's testimony. His lawyer said whether he had loved Naomi. Calvin said, "I gave her a roof when no one else wanted her." Then he folded his hands and stopped speaking. That silence lasted longer than the first, maybe 8 or 9 seconds. It had a different quality. Silence 1 felt like recognition. Silence 2 felt like correction. No one in that room believed him then, not because he sounded cruel, but because he had revealed the shape of his care without meaning to. Love does not improve its own case by calling a child unwanted. I heard a juror set a pen down, then defense counsel said, "No further questions," and the room started moving again. Subscribe, I will say it plainly. I owe it to her to keep telling this story. You subscribing is how her story reaches past this video. Subscribe and stay. The jury returned guilty verdicts on financial exploitation of a minor, unlawful withholding of vital records, tampering with Naomi's mail, and misdemeanor assault. They acquitted on part of the identity-related count because the state had not proven one piece of digital evidence beyond a reasonable doubt. Careful decisions and complete decisions are not always the same thing, but careful decisions still matter. Sentencing was held 8 days later, on October 18, 2024, at 2:01 p.m. By then I had the probation report, the restitution numbers, victim impact materials, and the inventory from the lockbox. Sentencing is not a speech a judge gives because the judge feels strongly. It is a set of choices inside boundaries. Some are fixed by statute, some are shaped by risk, some are shaped by what the victim will still need after everyone else has gone home. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. Before I spoke, the courtroom had that particular stillness that comes when people know permanent words are close. Naomi sat to my left with the victim advocate. Calvin stood when I told him to stand. I had made the decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I said, on count 1, I'm ordering 42 months in state custody, followed by 3 years of supervised probation. I said it slowly because custody should never sound casual from a bench. I am ordering that because this was not one act. It was a pattern. It taught a child that access to her own future could be turned on and off by someone who claimed to be caring for her. I said, I am also ordering restitution in the amount of $8,460 to Naomi Brooks for funds taken or redirected for your own use. Then I added, I am imposing a fine of $12,000 to be paid to the Franklin County Black Girls Transition Fund, which helps girls leaving foster care replace identification papers, secure housing, and meet school deadlines. The money had to point back to the kind of harm done. I said, "Your foster care license is revoked effective today, and for 15 years you may not foster, transport minors through any county program, serve as a court-approved guardian, or hold yourself out as a caregiver under state contract." Then I said, "Why? You used access to a child as leverage over that child. That access ends here." I said, "As a condition of probation after release, you will complete 300 hours with the County Records Restoration Project. You will sort, scan, file, and process applications for replacement birth certificates, Social Security cards, and school records. You will not work directly with minors." I wanted him near the kind of paperwork he had treated like property. Then I said, "There is one more part." The room got very still. "Within 60 days of release, you will provide a signed, written accounting of every document, letter, payment card, password, school record, and personal item of Naomi Brooks that passed through your hands, with dates and actions taken. That statement will be read aloud at a public meeting of the Franklin County Foster Certification Board and placed in the public disciplinary file. Harm done through public trust should not be hidden in private language." Then I said, "Within 72 hours through counsel, you will surrender every original document, every copy, every key, every password, every photo, every unopened letter, and every item belonging to Naomi Brooks still in your possession. You will also pay for 3 years of trauma counseling, all document replacement fees, all college application fees for the current cycle, and expedited processing costs for any delayed records." I wanted the order to speak to the life waiting outside the courthouse doors. I spoke to him directly after that. I said, "What you did can be counted in dollars, but it cannot be measured by dollars alone. You took mail, records, access, and time." I said, "To your family, if they carry shame today, I say this plainly. What was done here belongs to the person who did it." I said, "You were trusted to offer shelter. You chose instead to organize a young girl's life around what you were willing to release." Then I ended where I needed to end. "From this court forward, her life will not be organized around what you hid." Silence. 3 came down over the room after that. It was not the same as the first 2. Silence 1 came because truth entered. Silence 2 came because a lie emptied out in public. Silence. 3 came because something permanent had been spoken, and everyone in the room knew the future had just changed shape. From the bench it felt physical. No papers moved, no chair legs scraped. Even the deputy at the wall stayed fixed where he was. The first sound that broke it was paper. The clerk slid the recovered property envelope toward Naomi and the victim advocate. Naomi opened it with both hands and took out a cream-colored letter folded around a photograph. She looked down at it. Then she looked up at me. Her face did not change much. That is one of the reasons I still trust what I saw there. No performance. No sudden burst of feeling arranged for other people. Just stillness. Then she said, clear as anything I have ever heard in a courtroom, "You're my father." Nobody moved. Calvin looked at her, then at me, then back at her, but he said nothing. The prosecutor's hand stopped halfway to a file. The court reporter did not type for one beat, then another. From where I sat, I could not read the letter. I could only see cream paper, a dark-edged photograph, and Naomi's thumb pressed over one corner. I said, "We are in recess." My own voice sounded far away to me. I stood because judges stand when the room has gone somewhere the law did not prepare for. Naomi was still looking at me, not with accusation and not with relief. It was something quieter than both. I have not told you what happened after that in the room itself. Subscribe if you are willing to carry this story past this video. That is what subscribing means to me, not a number, a person who will remember this. Subscribe. As the courtroom began to empty, I stayed seated for a moment longer. From the bench, I saw Mrs. Porter do the first thing that needed doing. She did not rush to Naomi. She placed a hand on the back of Naomi's chair and held it steady. Then she leaned toward the victim advocate and said, "Don't rush her." I was close enough to hear that. It was the right sentence for that room. When I finally stood, the room was almost empty. I looked once toward the witness stand. A single pencil had been left on the ledge, rolling an inch at a time because the wood was not level. Because of what Naomi said, I recused myself from any later proceedings that could touch questions of family status. Another judge took those matters. Calvin Mercer appealed to the Second District Court of Appeals on November 12, 2024. He challenged the records count, the public statement requirement, and parts of probation. On September 9, 2025, that court affirmed the convictions and nearly all of the sentence. In plain language, they said the evidence supported a pattern of control and the conditions matched the harm. The appeal took just under 10 months. I expected it. I still checked the docket. There was one thing that happened later that I will tell you because dates matter. On December 3, 2024, in a conference room on the fourth floor, with counsel present and another judge presiding, a court-approved paternity report was handed across the table. Probability of paternity, 99.98%. I read the page, then I set it down. After that, Naomi said something to me I have repeated to myself more than once since this case closed. She said, "You were late, but you were not absent on purpose." I did not answer right away. Some sentences should be received before they are answered. There was another date that stayed with me. On August 21, 2025, I learned Naomi used her restored birth certificate and replacement Social Security card to check in for freshman orientation at Central State. She wore a blue badge on a lanyard with her name printed under her own photograph. That is the whole fact. I will leave it there. I still come back to the question I started with. How late can the truth arrive before it starts deciding things for everyone in the room? I do not know. I only know that delay does not make truth lighter. It carries the weight of all the time before it was spoken. If you share anything with Naomi, it may not be her exact facts. It may be the look I saw on her first day in court. Not fear exactly, not mistrust exactly. It was the discipline of someone who had learned to ration truth because too many earlier truths had been used against her. If you know that feeling, then hear me clearly. When you ask for your own records, your own account, your own name to be returned to you without bargaining, you are not asking for too much. You are asking for the floor under your own feet. And if you are more like Calvin Mercer, or if some part of what he did comes too close to what you excuse in yourself, then take the question I could not ask from the bench. When did care become ownership in your mind? Ask it while there is still time to return what is not yours without the law having to force your hand. I come back most often to the sentence Naomi gave the room before any of us knew the rest. My name was in there. Plain words, no decoration, no need for any. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you speak in the comments, speak the way people do when they understand. A room can still be changed by what is said inside it.